Welcome, everyone. We're going to get started in about 2 minutes. So glad to see how many folks are joining us today. I'll get started in about 1 more minute, just waiting for a few more folks to join. All right. Welcome, everyone, to our Trauma-Informed Lawyering Lunch and Learn. If we haven't had a chance to meet, I'm Lizzie Vogel, Senior Counsel at the Times Up Legal Defense Fund and Legal Network for Gender Equity team. I know it's a mouthful, at the National Women's Law Center. I'm really excited to hear from our esteemed speakers today, whom I'll introduce momentarily. And before we dig in, I did want to extend my very sincere thanks to those of you who helped make today possible. So first, to our attorneys in the Legal Network for Gender Equity, thank you for being here today and for all the work you do on behalf of survivors. Thank you to our fabulous presenters, Bridget Stump and Lindsay Silverberg. I'm so looking forward to learning from you today. And finally, my colleagues at the Law Center, specifically Danny Stewart, who you see on the screen, Christina Uella Lane, and Jennifer Mondino, whose work behind the scenes has been tremendously helpful. So today, as our title tells us, our focus is trauma-informed lawyering, which is something that we believe is critical for treating survivors with the dignity and respect they deserve, and critical to being an effective advocate. And we're lucky to be delving into this topic, guided by two people who could not be more qualified to speak on this. So that said, I'm thrilled to introduce our speakers, and I'm going to keep the introductions really brief so we can maximize the amount of time we have to hear from them. So a longer bio for each speaker, which you also have in your email, will be sent. It'll appear briefly on the screen, but I will not read that to you. So first, I'd like to introduce Bridget Stump. Bridget's the Executive Director of the Network for Victim Recovery of DC, so NVRDC. And this is a position that Bridget has held since co-founding the organization in May 2012. And next, I'd like to introduce Lindsay Silverberg. Lindsay is the Deputy Director at NVRDC and has worked as a victim advocate for a decade. So for today's agenda, the content for today's agenda was really driven by requests from you all in our audience, so attorneys in the legal network. The topics that we chose to focus on are in direct response to feedback that you gave us in a recent survey of what you'd like to learn more about within this topic. So to that end, we'll hear about best practices for representing clients who've experienced trauma, how to minimize trauma during all stages of the litigation process, and how to create and maintain healthy boundaries with clients. And we have a lot of awesome content and not a ton of time. And we recognize that you are going to have questions during the training. So feel free to add them to the chat. If we don't get to them during the presentation today, we will be sure to collect them and follow up via email afterwards with additional information that's responsive to those questions. And then just a few really quick housekeeping notes. This webinar is being recorded. We will share the recording and the slides from today on our website within the next few weeks. And if you have questions about any logistical or technical issues, please send them to me or Danny through the chat function on the screen. And to that, with that, I will turn it over to Bridget and Lindsay.
Hi, everybody. Thank you so much. We're looking forward to being here with you today. So we're going to jump in and sort of breeze through a little bit information about NVRDC, but you can always visit our website to learn more about us, and so we can get into the trauma-informed lawyering. piece of the presentation. So NVRDC, we serve all crime victims in the District of Columbia. Most importantly to know about us is that we believe in a concept called survivor-defined justice, which means that there is no one right way to deal with and recover from experiencing violence from harm, and that we really believe that the survivors that we're working with are the experts in their own lives and will tell us what is the best way for them to engage in the various systems available to them. As Lizzie mentioned, I come to this background as an advocate. I've spent the last decade as a hospital response advocate for sexual assault victims. And Bridget has been a crime victims' rights attorney for over a decade. And so we're going to talk to you a little bit about what all of that looks like and how best to help mitigate the trauma and make sure that we are not causing more harm to survivors as we work with them. So you'll see here just to note that like this content obviously can be really hard to talk about. Please take care of yourselves in any way, shape, or form. And if you need anything, always feel free to chat us or Lizzie or Danny. So let's jump in and talk a little bit about trauma's impact on legal advocacy.
Thanks so much, Lindsay. Thanks, Lizzie, Danny, everyone. It's great to see so many folks joining us on a summer afternoon. That's a testament to your dedication. So we're really grateful for that. So let's reflect on what we know it means to navigate the legal systems as a survivor of trauma. Perhaps Judith Lewis Herman, if you're familiar with her book on trauma and recovery, says it best. If one set out by design to devise a system for provoking intrusive post-traumatic symptoms, one could not do better than the court of law. And the reason we know this is true is because when we look at the research on best practices to support someone who's had a trauma experience, not surprisingly, right, when someone's power and control has been taken away from them, one of the ways we would mitigate that experience is to provide them with agency and choice. However, oftentimes the legal systems are not set up for the individual who is harmed to completely control the process, the decision-making power, and how they will experience that system. So what do we do about that? One of the things we like to highlight is that it's really, really important for us to look at what the actual research shows is how we can be the most supportive, the best support structure for a survivor of trauma in navigating these systems. And all of these really go hand in hand with how we develop the most effective attorney-client relationship. Of course, trust, a respectful approach, recognizing and honoring one's unique identities and how they might experience victimization. But really, really critical is this idea of advocating for choices and rights, because we know that that important element of empowerment is really critical to creating power with a trauma survivor, not power over them. And the reason this is so important when we look at the next slide here is there are lots of ways that the legal process is going to create a sense of danger or even really cue the survivor back into the trauma they've experienced, either an individual event, multiple events, or circumstances of their life where they've experienced trauma. We've had the opportunity to watch our three-part series, and I know Lizzie will share more information about that we've done in the past. One of the things we know about the neuroscience of being a trauma survivor is that while your brain and your body does this incredibly beautiful thing of keeping you alive during a life-threatening event, the challenge of surviving trauma is that your brain then looks for signs that are similar to that past event, and they can be tiny little reminders, like sensing something similar, someone's posture being the same as the person who originally caused harm, maybe a smell, really, really tiny reminders. Only 10 to 20% of an overlap of that original event is really required to revert a survivor to thinking they're under current threat, even in environments where it may not exist. And so I often think about, for survivors whose cue to their past trauma may perhaps be the environment that they're in. Let's think about survivors who experience harassment at work and have to continue engaging in that environment, and lots of other examples. For those individuals, it can be very emotionally disruptive on their life when their brain is constantly sensing danger in these environments. But the reality is, it is better for survival. We were actually hardwired to look for potential danger when we have survived an experience of trauma. The reality for lawyers is that sometimes we are actually the thing that is reminding them, causing that cue, because we have to talk about, the really, really nuanced details of their experience that often can trigger that 10 to 20% overlap. So that's kind of one of the challenges we encounter. When we look at the next slide here, similarly, there are so many opportunities for a survivor going through the legal process to encounter other signals that are going to make them think they're under threat. That can be something as simple as having to identify someone in kind of the pretrial investigative process. It can be sensing things that are similar. This even means actual, events, of course, but similar events that are imagined. So hearing about something similar to their experience on the evening news, proximity to life events, or even anniversaries of when they experienced that harm. But of course, the entirety of the litigation process, the preparation, the actual trial, having to engage in dialogue about it, and of course, all of the post, proceedings that can happen as well. For lawyers, I would say one of the greatest challenges that we now understand related to the neurobiology of trauma is that our memories of surviving trauma, the way we recall those events, the way we tell those events in the acute moments and the days that follow, are not the same as recalling every day-to-day memories that we have, like what we ate for breakfast this morning. All of those memories are sorted into this nice linear chronological order, thanks to the recalling being done by our frontal lobe. We know now through research, like what we find from Dr. Rebecca Campbell and others, that trauma memories are recalled differently because of our limbic system. And this is, again, intentionally by design. But what we have found through this data is that a survivor of trauma actually has an enhanced ability to recall the details, the events of experiencing trauma after they have had 2 sleep cycles from the acute event. And unfortunately, much of the legal system relies on what they interpret as credible memory, credible evidence, when it is closer in time to the experience. Now, this is true for things like our day-to-day memories, like what we had for breakfast. As it's closer in time, we tend to have more recall, more reliable, valid recall of that event. This is not true for memories that are tied to a traumatic experience. And what we know is that because the memory is enhanced after 2 sleep cycles, it's very, very common for a survivor who gives an initial narrative just moments or minutes after that experience, and then maybe a follow-up narrative days later for there to be inconsistencies. We would actually say, having worked with hundreds of survivors of trauma, that it is more likely we should experience that than not. And to be quite candid, if I was working with a client who had had a perfect, linear, exact memory from the initial narrative and every time they told it thereafter, that would be more perplexing to me than someone who has very regular inconsistencies, because that's what the science says should be the experience when someone survives trauma. The way we think about this is all of those trauma memories are really encoded onto lots of different sticky notes, and they're mixed up. And once a survivor has the ability to sleep, their brain is able to slowly over time attach the sticky notes in a way that makes more sense of chronology, time, and space. And while not creating a perfect linear memory, it's easier for those memories to be recalled after that. We technically say a 48-hour period. However, we know that not all survivors of trauma are going to go home and go to sleep. So sort of knowing when your client has had the opportunity to have the full 2 sleep cycles after the experience. So these are all of the challenges, and they're really just a summary of some of the biggest things that I think lawyers have to be really thoughtful about navigating. And so we'll talk a little bit, knowing what we have to face in helping our clients with trauma histories, with trauma experiences, really access their legal goals. It's really important to think about some of the concrete strategies we can use to minimize how trauma will present during the litigation process. I think the starting point is always that when we are creating a trauma-informed experience for any individual, particularly within the way they will experience an organization, a law firm, whether you're doing pro bono, maybe you're in civil legal aid, whatever role you play, The goal is that we are assuming you understand these 5 principles and you integrate them into how clients will experience you. The first is that we realize trauma is real and that it has long-lasting consequences on individuals' lives. We recognize that the way they engage with us as helpers is going to determine whether or not they are cued back in their trauma, and we can help them actually prepare for that experience. And that's really in the way that we respond to trauma survivors. So how are we recognizing when we see trauma manifesting in our interactions with them? And then how do we build practices and policies to actively resist causing more harm, as Lindsay mentioned earlier? And we actually added this 5th one. The 4 principles here are derived from research that was done with the Trauma Center and the CDC, and is really grounded in data of what a framework for a trauma-informed experience should be. We add the 5th one because, as Lindsay said, we believe that survivors are the experts of their own experience. And the only way to truly know if they are experiencing us as the provider in a way that is supported is to revisit and actually ask them about how they are experiencing us. So Linz, do you want to talk a little bit about some of the high level strategies? These are really the practice tips that we would offer to anyone within a legal environment. You don't have to be a lawyer to implement these. These would apply to the very first folks answering the phone or conducting a screening or intake, paraprofessionals. These are really, really helpful tools to think about when we may engage with a client, and that engagement may be something that reminds them of a prior trauma experience.
Yeah, absolutely. So one of the things that we would suggest, and as Bridget mentioned, from the point of somebody who's answering phones to anybody that's going to intersect with this survivor, is that you're standardizing these tools and tips as a way to help make sure that everybody has the same experience. We don't want to just make assumptions based on the way that someone is showing up in front of us that they need one thing more than another. So what we do is standardize it and make sure that people know that, and we offer these types of choices and tips to everybody. The easiest one, the sort of biggest one, is making sure that we're giving the client opportunities to feel empowered. And that can look like a lot of different things. I think the easy things that come to my mind are, where's a good place in the room for the survivor to sit? Do you want to sit in this chair with your back to the wall? Do you want to sit somewhere else? Asking somebody's name, what they want to be called. Someone might have, something on paper, but actually prefer a nickname or a different name. All we're doing are creating these opportunities for them to feel that they have power and choice in the way in which they're going to experience you as the provider. Our biggest tip that we love to give folks is a concept called road mapping. Road mapping is really just the idea that you explain to the person what you're going to do first, next, and last. And that would be, we would recommend in any interaction that you're going to have with them. So from the time that they call in to do maybe a screening or an intake, all the way through, as we're going to talk about what happens in the litigation process. And the reason that we suggest this is because what the brain is seeking after experiencing trauma is safety. And one of the ways that we can give that to somebody is to really guide them about what are the steps that are going to happen at each point in the interaction with us, so that we can help to try to mitigate the trauma that they might experience. And if their brain is really looking for this 10 to 20% overlap, the more information we give them up front, the safer their brain is going to feel, the less likely they are to be cued, and the more able they are going to be to fully participate in whatever the conversation is that we're having with them. The next one that we like to make sure that folks have just sort of in your back pocket is a grounding strategy. Because I think the important thing is with this, we're not going to avoid the client experiencing or reliving the trauma, right? What we can do is help mitigate that. And so we know that something, having to talk about their case, having to see pictures, any of these things really can cue a client into the response that they might have had during the trauma. And what we want to do is be able to give them some strategies to help their frontal lobe, what we often call our breakfast part of the brain, be able to come back online so that they're not responding from their fight, flight, freeze, or fawn response. The easiest one with that is to offer somebody water So for folks who maybe aren't into, you think of grounding strategies and you think of meditation and having to describe how you're a tree with roots, your feet are roots, right? Like water is such an easy one to offer somebody. I would generally do it something like, hey, we're having a really hard conversation. I'd love to take a break and I'm going to get myself some water. Can I get you some? Right. So at every opportunity, again, we're asking, creating choice, empowering the client. But water helps someone's autonomic nervous system regulate. So it's an easy one to do. There are things like box breathing, or sometimes it's called sky breathing. When you think about breathing in, you literally just trace a square, right? So breathing in on the up part of the square, holding it, breathing out, do it again. And you're just going to go around and around in a box. Breath is one of those things that also has been shown to help mitigate the experiences of trauma, to help regulate people's nervous systems. If you are more comfortable doing those, I suggest like you can look into them. We'll actually chat one of the resources for everybody here in a moment, but really making sure that you have just a couple of these, you feel comfortable, practice them before, because like we always say, you don't try to figure out a plan for the fire in the middle of it, right? We want to have it beforehand so that if a client starts to be cued, that we can help them experience that. And then the final one is thinking about healthy boundaries in attorney and client relationships. I think when we think about boundaries, people often think they can be unkind, right? That we're all in this kind of work because we want to be helpers. It's so important, though, that we are clear about what our role is, what we can and cannot do. And if that's kind of outside the limit of something we can do, it is not unkind to say that's not my expertise and I can get you connected. And we're going to talk about this specifically in one of the scenarios later on. Okay, so when we think about screening and intakes, I mentioned a couple of things, and we want to think about like, what is the interview purpose? Why do we do screening and intakes, right? For us at MVRDC, it is some about data collection, right? You might have to collect some pieces of information as a way, right, for conflicts, for reports, to show who you've served, all of that. But the other part of it is that it can be used for observation, data inputting, but we also really want it to be an empowerment tool, right? So it's the first stage that we're able to set for the client how they should expect to experience us. What choices are you going to have throughout the screening and intake and the rest of the interactions with me as the provider? And so it can be really helpful to help for that stage setting to guide the survivor in how they should expect to experience you throughout this process. Bridget, was there anything that you wanted to add about this?
No, but certainly invite folks, if you can think of other reasons why sometimes you're interviewing clients beyond what we have here, feel free to share those, and we'll come back to this in some of the practice scenarios. But I think for all folks, whether it's lawyers or paraprofessionals, the key here is realizing that while we might have needs for that interaction, we can turn those into also an experience that feels very empowering, where the client feels a sense of control over that interaction.
Okay, so thinking about the trauma-informed interview framework, this is a framework that comes from research where, you know, we want to make sure that these sort of 6 pillars, as we would refer to them, are instilled in what you're going to be doing. Some of them are going to be more easily achieved than others. Things like peer support might not be relevant in the space that you're occupying with folks, but we just want you to be able to see what a trauma-informed interview framework looks like. Bridget talked about empowerment and choice, you know, a person's lived experience with their cultural and historical lens, making sure that we're really honoring and recognizing the role of a person's lived experience and how that shapes their interactions with us or with the legal systems they're engaging. And then I think important for us are these trust and transparency and collaboration. So again, we're not going to get into a huge amount of detail into what these are, but encourage you to think about the ways in which when you're interacting with folks, you can build these pillars into the framework of how you're interacting with them. Okay, so trauma-informed interview approach is really clarifying the information and details that we need to collect about why we need to collect them. And what we're thinking of here is that you're going to have to ask hard questions. You're going to need information for your legal case that could potentially cue someone. And so when we're thinking about asking a question of like, often with sexual assault survivors, we think about this of like, what were you wearing? And you want to explain the why behind a question. So if we're saying, what were you wearing? And this often comes up with police, it might be because the police officer is trying to go back on video footage to figure out if there is, evidence that they can use in a case. The most important thing that we can do for that survivor is to give them that why, because if we don't, what their brain will do is really start to fill in the missing information with assumptions, with what society has told us about, it was their fault, whatever shame, blame they might be experiencing internally, they're going to fill in those sort of holes of information.
And so I would certainly say that your role is to make sure that the context is clear, like what you are asking for in any interview is very clear so that we're not giving anyone the opportunity to make assumptions about why we're asking that make them feel like a judgment. But what we also know from folks like Russell Strand, who's developed FETI, F-E-T-I, which is a specific type of interview approach, we know that we are more likely to get valid and reliable data about the details, the who, what, where, when, why, if we first ask the survivor, how did it make you feel? And if you go to the next slide here, we actually are given a really nice sort of step-by-step process of how do you engage in conducting a FETI interview with a survivor of trauma. And it's really counterintuitive to how we sort of used to think about the way we would collect information, where we're really focused on the pieces that we need. What the research shows is that we first understand how someone was made to feel, what they remember about how they processed the event, maybe very visual memories, because those are more closely tied to the part of the brain involved in trauma, and really making sure that we can validate their experience through the feeling part of it before we try to get them to recall all of the details. And what's fascinating is we know not only does this make the person feel validated, which is a key of a trauma-informed approach, but it actually gives them a sense of control of how they talk about the narrative. So it achieves that empowerment goal as well. And for us, it gives us more valid and reliable details of the information we need to be fully equipped to help them in the legal case. So let's talk about that part. We're kind of walking you through the chronological order of how a survivor might engage in your services. And as Lindsay mentioned in the trauma-informed framework, collaboration is really key. I think we often talk about trauma-informed lawyering only through this litigation lens. And it's really critical to know that if we are creating a trauma-informed experience, it's every single person who is a part of that legal team, even folks who are not lawyers, need to be prepared to ensure a client will have this experience. So in the litigation prep here, we're going to start by first really looking at what Lindsay described as road mapping. How do we help the client understand what's going to happen before their interactions with us, during, and after? And again, we'll talk about why road mapping is so important, but the goal is that it's my opportunity to help the client understand how they should expect to experience me. We get to agree on what that experience will look like. So during your kind of preparation of any interaction, as you're prepping for litigation or meeting with the client to start that process, you want to make sure that you are being very, very conscious of nonverbals. Not just the client's, but also your own, right? What might our behavior be communicating to a client about our comfort level, about our own questions, places where we are missing information? We set a very clear agenda. And when you have limited time, let's say in your first interaction, you only have a few hours, being really clear about that, and then establishing in the agenda what your top goals are and asking what the client's top goals are for that individual experience. So that we can continue to revisit that throughout the process together. We talked about standardization so that no client feels like something is unique to them, and that conveys some element of judgment or shame. And then always checking in with the individual about spaces where we can increase their comfort and making sure we're addressing questions and concerns they might have throughout the process. But during the interaction, when we look at the next slide here, it's really important for us to be thinking about context. Again, explaining to the individual why we are doing what we're doing and making sure that we are always asking for permission in how they experience us, all the way down to how we get clarity around issues where clarity is needed. And so we refer to this as a concept called mind the questions. And it simply means that we are mindful about how individuals experience questions. And so my recommendation is always to ask up front. You're going to say to the client, there may be opportunity or just sort of a part in our interaction where I'm going to need to ask you questions. I'm going to be needing to clarify, or maybe there are gaps and I need to get more information. How do you want to experience questions? Do you want me to interrupt you in the moment? Do you want me to write them down and we revisit them together? The most important thing is that we agree on a plan for how they will experience the ways that I get clarity, so that when that happens, it actually feels less jarring to the individual. And we're always being very clear. Part of how we ensure clarity is that we do that continual check-in, that they are comfortable and understanding the process and clear about, sort of what our role is and what's going to come next. After the interaction with any client, and it doesn't matter what part of the process you're in, but particularly in litigation prep, we always want to make sure that we are leaving them with a clear roadmap of what comes next. And there's actual science around when someone is a trauma survivor, that their brain is looking for those cues of danger, because the recurring question is in their mind is, am I safe? Oh, Lynn's, that's popping up on the screen there. Am I safe? What comes next? And so making sure that we are trying to preemptively establish what comes next, so the safety question mark doesn't start to trigger in their brain. But always, always, always expressing appreciation. This is helpful for lots of reasons, but continues to validate their experience and continues to make them feel a sense of trust related to oxytocin and how appreciation makes us feel. But once we've moved through these sort of before, during, and after, we wanted to talk a little bit about how do you navigate trial strategies? And I think this is often the part we get the most questions from lawyers in particular. And one of the things we didn't do when we were talking about the strategies is ask you all to think about, we do an activity with the stairwell. And we ask you all to think about, if I were to ask you to walk up a really long, dark stairwell and I give you no information and you had to get to the top, you would probably feel pretty anxious about that. But the second I started to say, there are 12 steps and they're about 12 inches in depth, and there's a railing on the right and a light at the top, all of a sudden that dark stairwell goes from a place of deep uncertainty to a place that looks more like this, right? It looks same objective, you just got to get up this flight of steps. But the more information we can give someone about how they experience what they have to accomplish, all of a sudden, the less anxiety we have created simply by eliminating uncertainty. It's quite a powerful tool, and it is simply the concept of road mapping. So for direct examinations, we want to be very clear on our role and make sure we prepare and practice. Again, if the brain does not know how it's going to experience something, it will be looking for a sense of danger that can cue the fight, flight, freeze, or fawn. I think the more challenging place is actually when we start to think about cross-examination. And this is a space, I think, for more seasoned and experienced lawyers, we are not afraid to say to the client, I need you to feel like you can tell me the worst possible thing that can come up, right? Similar to sort of direct, we're going to make sure we're practicing. We want them to know what to expect. We want to eliminate uncertainty to the extent that we can. But really, the preparation is around making sure that we are not sugarcoating things. We are not making it seem easier or simple because we're simply afraid that they're not going to be able to manage it. And we're also not fear-mongering, right? Again, trust and transparency. We're being direct and honest about what could come up and what they should be prepared and expected to navigate during cross-examination. I will also say it is very, very important. We've had this come up in a case that if we see during cross-examination a client who is manifesting in their trauma, that means their brain has been cued, the frontal lobe is offline, and let's say they were someone who had a freeze reaction during their particular experience. And all of a sudden, we see glassy eyes. Like, we can tell they are not in the room anymore. They're not in the courtroom. They're not there. They're not paying attention. They have been activated. And we as the lawyer want to have a plan to check in with them. I will tell you from experience, judges are not always receptive to us in the moment we're seeing that trauma activation during a cross-examination, to us checking in with our client. And so being really clear, how do we create a plan, not only with the client, with the support systems in the room, about who will they look to, what can they expect if we're starting to see that? Can we communicate to the court in advance about breaks and how we ask for breaks? All of those sort of preparation around mitigating the trauma activation become much more important when we're fully thinking about how we prepare someone for the litigation process. And so it's also really critical, as we go to the next slide here, you've moved through it and you're at the point where you get a little bit of breathing room from a kind of a litigation sense. But then one of the really key elements around maintaining an effective attorney-client relationship, again, is being really clear about how do they experience us in all of the post proceedings that follow. And this is often a point where I think we see clients get very frustrated with teams that maybe they had a lot of trust and had a great experience. And it often comes down to the idea that they're expecting information or communication in a way that does not align with what is either realistic or what is available. And sometimes that means calling clients and saying, I'm checking in with you because we agreed to check in every X amount of time, and I have nothing to tell you. Like, it is the willingness to call and say, I don't have any information, but sticking to the plan of how we will talk about what comes next, and how we share updates with the individual. Linz, why don't you talk a little bit, just high level trauma-informed language considerations?
Yeah, absolutely. And I saw that we got a really good question about how do you know if someone's experienced trauma, which Bridget can answer later on. But when we think about trauma-informed language, we have these words in English that can often convey judgment without intending to. And I think the ones that most frequently come up are the words just and only. And, when we think about the reasoning behind using trauma-informed language, it's just another space, it's another way that we can make sure that we're being considerate, we're empowering folks, we're not conveying judgment about their experience. And what we hear often from survivors that we work with is that the people that they tell, sort of the first person that they tell about the experience, really shapes the way in which that person, the survivor, continues to seek and engage in help-seeking behaviors. And so we want to, in all ways, shapes, and forms, create this empowering experience with them. Language is a really key component of that. And so what we think about with trauma-informed language, like I said, just and only might be words that we could use to ask a question because we need more information. A very valid question of, like, was it only one offender, or was it just XYZ harm that happened? What the survivor is hearing, though, is it wasn't that bad, it could have been worse, right? And so when we think about language, words like that, we really want to try to avoid. And as you can see, I just did it. Now that I've told you those words, you will use them. And, important if you do say something where it was like, oh, it was just one offender, it was only this, revisit it. Say, hey, I don't love the way that I asked that, and I just want your permission to know if I can try again. There's lots of other language out there that we can be kind of considerate of, just high level. Like, I really suggest that people don't use the word gentleman to describe somebody who's caused harm. If you think about what the word actually means, that person who caused harm does not represent that. So that's just another word that we tend to use to try to stay away from.
And the reason we talk so much about expectation setting and road mapping is because there is really, really important science to understand about trust. And it's interesting, collated from research done by folks like Paul Zak, who's a neuroeconomics researcher, and he studies things like what does it take in the human interaction for someone to both feel trusted and for someone to create a sense of trust. It again is tied to sort of various hormones and oxytocin, but at the most basic level, trust is not what we think. It is not these big heroic moments where we come in as the helper and save someone. Trust is simply the person doing what is expected of them. That's it. It's little moments over time where we have established how we should be experienced and then actually doing that. And that's why the concepts we've talked about around road mapping and trust are so tied together and really go hand in hand. So with that, I do want to respond to the question from that we got in the Q&A. Actually, this is one of my favorite things to talk about before we move in to some of the practice scenarios. As Lizzie mentioned, these practice scenarios are developed specifically from questions and feedback that was pulled from the survey. So hopefully they feel very responsive from to what folks are here for and what's going to be helpful. But we got a question about how do you determine from the start of representation if someone has experienced trauma? And what I will say is, what you can't always, that's sort of the annoying lawyer answer. But at the end of the day, and certainly if you haven't seen it yet, I would suggest you watch part 1 of the 3-part series that really goes into detail around how does the brain and the body respond? What is the neuroscience of being a trauma survivor? And the biggest takeaway is to know that trauma is not defined by an event, which is how we were actually taught. We were taught to believe that it's a specific type of event, and that event often requires some sort of direct or physical injury. Trauma even comes from the Greek word wound. And it's just been in the last 10 years that we're starting to understand that a trauma experience can be both that, but also being in proximity to someone who's experiencing the direct wound. It can be a mental injury. It doesn't have to be this physical injury that we always kind of thought about. Keep in mind, trauma isn't defined by the event, it's defined by the person who experiences that event. And so anything, right, based on one's identities, lived experiences, if that experience is threatening, dangerous, out of my control, so much so, as Dr. Sandra Bloom defines trauma, it is simply too much stress too fast, where I become disconnected with my own understanding of how I navigate the world, with my family, and with my community. And so it's really challenging as helpers, particularly if you are someone who's represented a lot of survivors of trauma that have had really egregious experiences. One of the most important things to be aware of is that we establish a threshold that we sort of use to individually say, like, these types of things cause trauma and these things don't. We were sort of designed to think about the world that way. It creates almost like a sense of safety. But the reality is any event can cause a trauma experience if for that individual, it was threatening, dangerous, and out of their control, so much so that it disrupted the way they felt they understood the world. And so again, if you're interested in learning more about this, we have a whole 90-minute webinar that you can watch. It's recorded. And I see a chat. Lizzie's going to share those in the chat as well. But with that, we're going to move into the first practice scenario here.
And just a quick update. So the chat feature, even though it is enabled, is not working. So Bridget and I are actually going to talk through the scenarios about how we would respond. If you have questions or comments, please feel free to put them in the Q&A. That is working, and we're getting those. But
thank you, Lindsay, for giving me that heads up as we're moving into them. That's great. And so for this one, I'll go ahead and read it to folks. Do feel free to just sort of, follow up with additional questions in the Q&A. And if we don't get to them, as we mentioned, we'll follow up. But this one specifically was focused around the issue of boundaries. That was quite thematic in the survey. In this particular scenario, we have a prospective client that comes to you. They're seeking representation. Their case has been stayed, and they're looking to reinstate it as soon as possible. They kind of want to reinitiate this experience. You are juggling a lot of competing deadlines for other clients, and their cases feel more pressing. I feel like we all can relate to like this experience. The prospective client emails you daily requesting updates. How do you explain to that client that their case is important and a priority while also setting realistic boundaries for yourself and for expectations around how quickly things can move forward? And so we'll just kind of pause there. That's the scenario. So prospective client feels a sense of urgency. It's not really fitting into our capacity load and what we're prioritizing at the moment, but we don't want to convey a sense of it not being important to us. Lindsay, do you want to open with sort of how you've navigated this with the screening and intake staff?
Yeah, absolutely. So I think I will just comment that, like, Bridget talked about trust. We often hear that this sort of experience where maybe the client is not getting updates, reaching out, not hearing back, feels like they're being ghosted, is really frustrating for them, right? They think they've done something wrong. They think you don't care. So our suggestion would be is that you're very upfront, that you're setting this from the screening and intakes, and with the realization that, like, you will have to revisit this with a person. If you are a trusted individual for them, you've shown up when others haven't, they believe in the services you've given them, they're going to ask you, right, to sort of push your boundaries. We would expect that to happen with the client. It is your job as the provider to remind them of, like, hey, your case is important to me. Here is the timeline that we talked about for reinstating your case. I am not able to commit to giving you updates on a daily basis. What I can commit to is whatever that actual realistic piece is. So every week, every 2 weeks, I will call you to give you an update. But you want to be able to be upfront and say that, that doesn't mean I don't think this is important. What it means is that I don't want to make you a promise that I can't keep. And so we would suggest that you're really clear about that from the beginning, but then also continuing to reinforce that throughout your interaction with them, and put it on yourself. You don't want to disappoint them. And what you have time for and can commit to is this particular thing.
And I'll just say that part of the kind of perfect world, which may not always be true based on where the client is trying to co-create that communication plan so that you both agree to it. And integrating those opportunities for power and choice into that. So it might be something as simple as, okay, we've agreed that you would like an update every week. How is that easiest for you to receive? Do you want me to call you, or do you want an email? Do you want a text? Like, giving them the opportunity to say, like, this is the best way. Maybe they want to, like, check in over the phone because they are still going to want to say, are you sure? Are you sure? Has anything changed? But whatever you agree to, being able to stick to that. And I think one of the challenges sometimes in scenarios like this is recognizing that sometimes that daily need for information is very deeply tied to the anxiety over the unknown, right? Like, they don't know if the case will be reinitiated. They don't know the success of that. And it can also be tied to other sort of challenges that the client is navigating, whether that's mental health barriers or anything else related to what it means to be a trauma survivor. And one of the questions, if we look at the next scenario here, was really tied to this idea of what do we do when we know we are not going to solve all of the problems, all of the needs that a particular client has. So Lindsay will read this one to you and then kick off the conversation.
So this one says, my client appears to be struggling with their mental health. How can I suggest that they seek out mental health services, and what is the best way to connect them with services? The tactic that our team typically takes with this is, like I said, my background, I'm not an attorney, I'm not a social worker, I'm not a therapist. As an advocate, or as an attorney working in this space, we always think it's important to be clear about where your sort of role boundaries exist. So I might say something to a survivor like, this seems like it's weighing heavy on you, or this is a lot to deal with on your own. There are people who can help give you tools and strategies, and even just a safe space to hear you out about what's going on in your life right now. I can't always do that. I have a very specific role in terms of, like, what I can help with. And I want to get you connected to the best resources for somebody who can help kind of give you those strategies about how to deal with this. Are you potentially interested in learning more about a therapist or talking to somebody? I have some really great folks that I could connect you to. Again, right, we're giving that survivor choice. I think the thing you have to be okay with is the person saying no. That comes up a lot where we ask and either the individual's not interested or not ready, right? That's okay. And you have to be okay with that they have the right to say no and not want to engage in the services, even if it feels like it's very clear to you that they need it.
And I'll just add a tip that Lindsay often talks about that's been really helpful for me in that context. When you're making the offer and you're being as sort of empathetic and compassionate as possible about how you navigate, like, this is not a support I offer, this is the place where we can get you connected to that support. Again, standardizing it, it's always helpful to be like, we offer this resource to anyone going through any sexual harassment case because of the consequences of that experience. Like, making it standard can really help it feel like not judgmental and individualized about that person's mental health. But I also think just being prepared that if they say no, you can talk about how they have channeled resiliency when they're struggling in the past. And you can start to get them from a sort of soft skills to identify what is going to help them through the ways they might be experiencing challenges during their interactions with you. And slowly over time, as trust is developed, your offer for the resource may be more they may be more receptive to it as they've built trust with you. And so again, I think being conscious that like it may take both time and repetition. And both of those things are not always a perfect way to accomplish them getting connected to the right support, but being committed to the process of revisiting it with the client over time.
And I think the other piece of that is just being clear about, like, if the person says no, you've established like that's fine. If at any point you want to revisit it, you can bring it up. I will plan to ask you in 3 months or so if there's any additional services or things that I might be able to offer you or refer you to that maybe you've changed your mind about, right? So again, not trying to sort of stigmatize them by being like, oh, you seem like you're having a really hard time, I'm going to continue to offer this, making it standard to say, I ask everybody. If they're not interested the first time, maybe you've changed your mind later down the road, and that's fine.
That's a really good point. So on this next one, we're really trying to tackle the challenge of burnout as it relates to individuals, to colleagues and coworkers. We know, right, that things like vicarious trauma come from, and we always say it's not a matter of if, it is a question of when you sit in close proximity to carrying stories of trauma survivors. That is a likely experience when you are frequently engaging with and supporting those who have trauma histories. So the key questions here are, what do healthy boundaries look like? Lindsay and I really loved like practicing through these questions. These are verbatim questions that came from the survey. How can I avoid burnout? And then what can I as a manager do to support junior staff who do a lot of client interviews to avoid burnout? Lindsay will talk about that one last, but in terms of the first two, and we do an entire training on vicarious trauma as it relates to organizations, building resiliency and individual resiliency, if you're interested in that. But when we talk about what healthy boundaries look like, again, the annoying lawyer answer, it depends. It is so unique to the individual. When we talk about things like vicarious trauma and trauma histories, they are very, very common experiences, but so unique in how they're experienced. And that is the challenge. A healthy boundary to you may look very, very different to a coworker or to a colleague. The key is that you establish them, you agree on them, and you revisit them. Like, that is the key, that you know, this is what I need to continue to show up and function at my best. Because the reality is, number two here is not a real thing. There is no avoiding burnout. We prepare, and we minimize, right? This is like the concept of, when I think about like, and that's not to say that like everyone gets burnout, but I don't think like as a holistic concept, we can say that we can put a single thing in place in our life and that is going to avoid burnout. The strategies to build resiliency, which are the plans we develop to really prepare and mitigate the consequences of vicarious trauma, are grounded in all the different elements of our lives, whether that's spiritual, physical, mental, social support, all of those things, and the need that we have for those things to feel totally like whole and healthy are different for each of us. And so the suggestion we would make on preparing both yourself and your teams for resiliency is being really, really clear about the strategies that science has said help us build resiliency for hard moments. At the highest level, it's things like mindfulness. And I don't just mean meditation. These can be things like practicing acts of gratitude within your teams, within your own lives. Gratitude is deeply tied to happiness and health. Like the science shows, if you practice one thing a day where you think about what you're grateful for, it can double your sense of happiness. There are also techniques like breathing, other things that can keep us really grounded in the work. But a sense of purpose, we call it making moves. So movement, how do you integrate movement into your conversations, into your life? Interesting research shows that we are more likely to receive and convey difficult information if we do that while we're walking. So thinking about supervision, how do you have feedback processes where there's some element and ability to get up and just have movement as a part of the way that you dialogue with your teams that are doing really challenging work. And Linz, do you want to talk about what you've done as the supervision structure?
Yeah, I think one of the things that we've built in that's been really impactful for staff is in every, sort of bi-weekly conversation that we're having with junior staff members is saying, what are your self-care needs right now? What are you experiencing in terms of burnout? What can we do to help support you? And just those 3 things, right? Being able to name it, ask it, and really having a plan with each individual person has helped folks, one, feel like they don't have to bring it up. So if they are experiencing it, if they are feeling it, the fact that they know we're going to ask is important to the sense of that they can sort of answer that honestly without judgment, right? Because it's just, again, it's standardized. And so we always like to think about when we hire folks, building that plan up front to say, like, what are the things that you need and you do in your life to help take care of yourself? How can we help support you in that to make sure that you're engaging in them?
We're going to skip. Yeah, I think we'll just skip this one and we'll send it out when we send out answers. I see we have another Q&A coming in. I really appreciate that question, Garrett. That's one of the harder things, I think, to navigate. We're going to turn it back over to Lizzie as we close out for today. But before we do that, I practice acts of gratitude. It's something I deeply believe in. I make my kids do it every day. And I do just want to express that you all do a lot. You do a lot to support your communities. You give often selflessly to be able to participate and engage in this critical work. We are deeply grateful and really honored that you spent the last almost hour with us. So thank you for your time and attention. And Lizzie, thank you to you and your team for just continuing to make this information available to so many folks that are doing this incredible work.
Thanks so much for saying that. So thank you so much, Lindsay and Bridget. That was really incredibly informative and insightful. I know that staircase metaphor really resonated with me, maybe partly because I felt like our attic was haunted as a child. So yeah, that really spoke to me. Before we log off, I did have a few really quick final announcements. First, a huge thank you to our fantastic presenters. Bridget and Lindsay, thank you so much for all the work you put into preparing this, the insight you provided to us with this webinar, and to the work you do every day. It's really inspirational and so important. And thank you all to those of you who attended today. We really appreciated your engagement in the chat and apologize for the technical issues, and thanks for rolling with that. So before I let you all go, I did want to be sure to mention our summer membership drive for the Legal Network for Gender Equity. Those of you who are already in the Legal Network should have received an email about it last week. It's hard to believe that it's already been 5 years since we launched, and we have made real impact. We've received more than 10,000 requests for legal help for survivors, but our work is far from done. We are still getting more and more requests every day, and survivors need your support. So to that end, we're organizing our first membership drive. As you likely know, members of the Legal Network have access to regular high-quality trainings like today's. You get regular updates on key issues in the law. Legal Network attorneys can apply for funding from the Time's Up Legal Defense Fund to defray costs and attorneys' fees in cases involving workplace sex harassment and related retaliation, and for public relations support. So we would ask if you are eligible to be in the legal network and are not already, please consider joining. There's a website at the bottom of the page where you can learn more to apply, and Danny has added information about how to spread the word about this membership drive to the chat. And if you're already part of the network, please help by referring a friend. And that link in the chat will help you do that. And as part of the membership drive from now until the end of July, new members and existing members who refer a new member will be entered to win one of 3 gift certificates to Just Seeds, which is a super cool cooperative art shop that's committed to social, environmental, and political engagement. And on the last slide, we would really appreciate it if you would take 3 minutes. I promise you, it's only, I think, 6 quick questions, 3 minutes before logging off to complete a brief survey about today's webinar. As you saw, the feedback you give us in surveys does drive the content that we seek to create and to provide to you. So please do consider completing that webinar. We take your feedback really seriously. Danny has added the link to the chat. You're also welcome to hold your phone up and use the QR code if you prefer that. And lastly, please feel free to follow us on social media, and all of our past webinars, including the ones that Danny linked to, the 3 parts in the chat. All of our past webinars can be found at the link in this purple box on the screen. And it is 1 p.m. Eastern, so I will let you all go. But again, tremendous thanks to our fantastic presenters and to our engaged audience. And we will see you for our next webinar. Thanks, everyone.
Thanks, everyone. Be well.